Thank you, Chief. On to 10-2. Oh, yeah. Councillor Elliott can come back. Thank you, Councillor Almeida. Conflict of Interest Expenses Policy 273, Corporate Officer.
Sorry, I grabbed the wrong. So what you've got on the agenda today is proposed conflict of interest and legal expenses policy. As you know, the community charter requires elected officials to declare and deal with conflicts of interest in accordance with a set of prescribed statutory rules. The onus falls on each elected official to identify when a conflict of interest exists and to take the appropriate measures to deal with it. These provisions are found in sections 100 to 109 of the Community Charter, and the basic rules relating to conflict of interest are found in sections 100 and 101. So section 100 stipulates that if a council member attending a meeting considers that he or she is not entitled to participate in a discussion of a matter or to vote on a question in respect of a matter because the member has A, a direct or indirect pecuniary interest in the matter, or B, another interest in the matter that constitutes a conflict of interest. Usually that's a non-pecuniary or non-financial type of interest. Then the member must declare this and state in general terms why the reason why the member considers this to be the case. Once that happens, the member must leave the meeting and must not participate in any discussion of the matter at such a meeting, nor vote on a question in respect to the matter at such a meeting, or attempt in any way before, during, or after a meeting to influence the voting on any question in respect to the matter. The elected official may return to the meeting only once the matter that gave rise to the conflict is no longer under discussion, or if the council member has obtained a legal opinion indicating that there's no conflict, and that's found in section 100 sub 4 of the Community Charter. So the crux of this, though, in terms of the proposed policy that you have before you today, is that getting advice as to whether a conflict of interest actually exists or not is an important responsibility of every council member to consider in relation to their own circumstances. The draft conflict of interest policy, or conflict of interest and legal expenses policy, 273, provides options and clarity around seeking legal advice, the onus for doing so, the responsibility for the expense, and the ownership of the solicitor-client privilege pertaining to that advice. And I'm going to stop there and perhaps answer any questions that you have about the proposed policy rather than going through it section by section.
Questions? Councillor Isaacson.
Yeah, thank you, Chair. Through the Chair to staff, I think one possibility that I don't see in the policy would be a situation where maybe staff, maybe the individual in question and the CAO do not feel that it is a need of the city, or the member doesn't feel it's in a need of the member to seek legal opinion, but that council by majority vote decides that they want to do that. Is there space in this existing policy if council decides that, you know, it is in the city's interest to get a legal opinion on a specific matter, a specific conflict of interest, for council to direct staff to seek that? And like, yes. Is that appropriate, and can that fall within the bounds of this existing draft of the policy?
Yeah, so it's always an option for council to resolve that the city get a legal opinion in respect of a matter. If, for example, the situation arises that you alluded to, because the policy as it's proposed and laid out before you now provides for a situation where a situation arises and the CAO is advised, whether by the member themselves or by somebody else, that there's a possible situation. The CAO is the one who decides on behalf of the city whether or not the city ought to get a legal opinion on the city's behalf. So it doesn't specifically lay out that the option exists for council to resolve to do that. So that exists no matter what, regardless of this policy. Or, you know, we could add that as one of the general stipulations under Section 5 at the end, that it's always council's option to direct staff to seek a legal opinion.
And in that case, the legal opinion would be kind of owned by the city. It would be a legal opinion to the city as opposed to the individual in question.
Yes, it would be the city's solicitor-client
Yeah.
relationship, yeah.
Councillor Dutt.
I'm just going to stick to questions right now. My comments, I think, will come later. But going through it, I think what policy is trying to say is the city won't pay for legal opinions that a councillor gets if the councillor gets a legal opinion to see if they're in a conflict or not. I think that's the gist of it.
The main thrust of the policy is, yes, that it is it's the elected official's responsibility to make that call, and if they feel that they ought to get one, then it is up to the elected official to do so, unless the city feels that it's in the city's best interests to seek that legal opinion.
Well, it's up to the individual to get a legal opinion if they think they need it. That's a pretty simple paragraph. So my question, reading through it, I was trying to, over the last couple of days, read through and understand it. So can you tell me what paragraph 3 does that paragraph 2 doesn't do? Because I can't understand what it means.
Right, paragraph 3 versus paragraph 2?
Paragraph 3 says, after notifying and consulting with the impugned council member, the CAO may choose to notify or consult with the mayor or the acting mayor if the possible conflict relates to the mayor or someone raises a possible conflict of interest to the CAO. And my reading that, I've read it quite a few times, trying to backwards and forwards, but I think it says the same thing that number 2 says over again. Paragraph 2 says over again. I don't understand what difference is and what paragraph 3 is trying to accomplish.
I think paragraph 3 is really just laying out that if the CAO feels that it's appropriate or wishes to consult with the mayor, or if it's about the mayor, then with the acting mayor, then the CAO is at liberty to do so. Doesn't really state anything about that in the previous paragraph. Really talks about where a possible conflict of interest is raised to the CAO either by the particular member or by someone other than the particular member. And then the CAO will consult with the member and determine if it's in the city's best interest to seek legal advice on behalf of the city. So it adds another layer about consulting with the mayor if the CAO deems that something that's appropriate in circumstances.
But it only adds another level of consulting with the mayor if the conflict relates to the mayor. I would think if you were consulting in paragraph 2 with the person complained about and the person complained about was the mayor, you would be consulting with the mayor. I think probably doing it once would be enough.
A point of privilege. I think I see where the confusion is. That line, or the acting mayor if the possible conflict relates to the mayor, is almost like in brackets. It's not about a conflict relating to the mayor, but it's about if, for example, someone brought a concern about me being in conflict of interest, 2 is true, the paragraph 2 is true. And 3 lays out the ability to the CAO to also connect with the mayor. In the case, though, that the mayor is the impugned council member, then the acting mayor would be the person that it goes to. So it is like, I also read it weird twice, but it adds an additional potential step to consult with the mayor on a conflict, and then that that conflict relating to the mayor is about the CAO approaching the acting mayor. And it's almost like that phrase could be in brackets. I don't know if that clarifies things a bit for you or muddies it further, but yeah, I feel like that sentence could be read two ways and be a little bit confusing.
I'm just trying to understand what is actually happening here. And paragraph 4 said the CAO must maintain the confidentiality of a third party. But what does that mean?
Yeah.
In relation to your first question through the chair, Councillor Dowd, number 3, paragraph 3, if using an example, if someone had said that Councillor Isaacson was in a conflict of interest and I approached Councillor Isaacson and talked to them, I wouldn't necessarily go to the mayor and have a conversation and say that, you know, someone had approached me about Councillor Isaacson or another councillor. Number 3 provides that opportunity to do so if I felt it was necessary. Without number 3, basically that conversation shouldn't be taking place. We shouldn't be having those conversations with the mayor about potential conflicts of interest that involve other elected officials. So that's for that one there. And then, sorry, your question in relation to number 4 is in regards to confidentiality. And what was that, sorry?
Yeah, I assume the third party would be someone raising a complaint.
Correct.
And paragraph 4 says that the CAO must maintain the confidentiality of the third party. So that means you don't tell the mayor or the impugned council member or anybody else who the complaining party is. Is that true?
The idea would be that if, for example, whether it's a member of the public or whether it's a member of council that comes to the CAO and says, here's some circumstances that I don't know if you're aware of, but they give rise to what I consider to be a concerning situation, and, you know, perhaps you should investigate it. Then if the CAO goes and has a conversation with the impugned council member, they're not going to necessarily tell that council member where that information came from unless the person who brought it up grants permission to provide that information, or if that person has publicly made that information available already themselves. So those are the circumstances under which that would play out.
Got one more question, I guess, right off of this, and I probably have another for the second round. But down at the end, number 4, it says staff may provide advice based on the facts as they are aware of them. It doesn't say the facts, it says the facts as they are aware of them, and staff might do that. What kind of advice would they be for providing, and who to?
Sometimes I think actually, you know, I was reading that just prior to the meeting now, and I was thinking to myself that really that ought to say staff may provide advice based on the information and the facts as they are aware of them. So anytime that a situation comes up with respect to a conflict of interest, it's regarding a certain set of circumstances and a certain set of facts that surround those circumstances. Staff may or may not be aware of all the facts. Staff will have information at their disposal to look up information from previous council meetings, previous issues that have come up. But the council member themselves are going to have a lot of information about their own circumstances and how they play into the situation, whether or not the situation gives rise to a possible or potential conflict of interest. So there's a big fact-finding, information-gathering process that ought to be conducted by the council member themselves and by staff. You know, if we're trying to make a decision, the CAO is trying to make a decision about whether or not it's in the best interest to seek independent legal advice on behalf of the city, we need to know all of the facts. So when the CAO has a consultation with the impugned council member, the CAO is going to be asking probing questions about all the circumstances that might relate to the set of circumstances giving rise to the situation. So it is a bit of a fact gathering and information gathering process, and I think we have to be diligent about that as staff, and council needs to be diligent about it as well. So that's the intent there.
Actually answered one of my other questions that I was going to save till later, but that question was going to be, isn't this just making a policy out of a CAO's investigation? Is it that the notice and the notice and the consultation is really about the CAO taking on the role of an investigator, doing an investigation, and then providing advice to the mayor or somebody else about what to do about that investigation?
Well, through the chair, I think that it's partly that, but it's also in large part a policy that identifies and gives guidance to not just the CAO, but to councillors as well, council members, about their own responsibilities and where those responsibilities lie and what their courses of action are, and really sort of clarifies the lay of the land, I think, for everybody involved. At our end, we will undoubtedly develop internal policies and procedures in respect of how we approach that, how we record the information, so that if a conflict is declared, we've got a register of those conflicts, and so that we're aware when items are coming forward on agendas in the future, that we need to be making sure that council members are not putting themselves in harm's way, or that they need to be alerted to the fact that they're going to need to recuse themselves if a matter is coming forward on which they've declared a conflict of interest. So there's a number of different steps that we need to follow and make sure that things are clear, that everybody's clear in terms of their roles and responsibilities.
But as questions, I can save
Councillor Elliott.
questions till later.
Councillor Elliott.
Thank you, Chair. So the process or the policy is laid out in separate clauses, and clause 2 seems to include a process that lands where the CAO makes a determination. Is it intended to limit the actions that happen for that determination, or is it also, and this is what goes back to what Councillor Dowd was saying, is consulting with the mayor part of making that determination on what's in the best interests of the city, or is that a independent review by the CAO that is not part of and is done before one would consult with others?
I think that through the mayor or through the chair, the CAO needs to assess all of the circumstances with respect to the particular matter after consulting with the council member, and make a determination as to whether or not it's in the city's best interest to seek a legal opinion on behalf of the city, or whether it's something that is going to remain within the sphere of the council member, and it's up to them to seek a legal opinion if they feel that they ought to do so.
Yeah, I got all that.
The extra step though of consulting the mayor or the acting mayor is only an extra expansion of the parameters of what the CAO may or may not choose to do. It just provides that extra level of consultation if the circumstances warrant a situation where that's going to be helpful, or if the CAO assesses that it would be helpful to have that conversation, then, and it's not going to cause any harm or disadvantage to anyone, it may be beneficial for the CAO to have that conversation. So that's the only intent there.
Yeah, the reason I brought it out was not because I thought there was harm one way or the other. I was thinking about it as outlining the intention around like a statutory decision almost, and the confusion it causes by being in two separate sections. If it's part of section 2, it should be part of section 2. If it's a separate notion, it should reference, and so that it's clear what may or may not be considered in that decision to be a clear policy. And the only time that could hurt the city is if we do something that appears to be different and someone challenges the decisions based on it. Well, it's not how you said you would make your decision. And so just trying to make sure that the wording is clear as to what may be considered as part of that decision or not. And if everything is part of that, it should say so.
I hear what you're saying. And that could be moved up into that section. However, I think what you're also saying is that anything and everything that the CAO is going to consider in terms of making a decision as to whether or not the city ought to get a legal opinion for itself should be contained within that section. That is something that we wrestled with a little bit ourselves, and we did seek legal opinion on whether or not that ought to be contained in there, have some criteria that would guide the CAO in terms of how to make that decision, what kinds of things ought to be considered. The advice that we got back was not to basically constrain the parameters of decision making for the CAO, because it's very difficult to anticipate what all those circumstances may entail, even if we use language like without limitation, and that kind of thing, so that it's more of a guide or intended to be a guide. The response back was that that's well and good, and that yes, you would definitely do that if you were going to go down that path, but the advice was still not to go down that path, that those kinds of things tend to start constricting after time, if not at first, and that we would be better off to keep the parameters of the CAO's discretion more open-ended. So,
Carry on.
Mayor.
To the chair, pursuant to the report of the corporate officer dated for the committee of the whole meeting of March the 3rd, 2026, entitled Conflict of Interest and Legal Expense Policy 273, that the committee recommend that council adopt Conflict of Interest and Legal Expense Policy 273.
Discussion?
Don't need a seconder.
No.
Looking for discussion. Councilor Isaacson?
Thank you. Before I make an amendment, I just want to check with staff. I was thinking of making the same motion of the mayor, but making including two changes. One, you mentioned the word facts. You maybe wanted it to say information and facts in section 5, part 4. Is that correct?
I think that would be helpful.
That would be helpful. And then the other one would be to add a clause that council can direct staff to seek legal advice, just making that explicit, because future councils may not always remember what this discussion was, and to know that is also a potential avenue to get an opinion. And so the other amendment would be to add a clause that council can direct staff to seek legal advice at cost to the city, or whatever that wording makes sense, but to add that clause. So before I make an amendment motion or motion to amend, I just wanted to check with staff first whether those two make sense. Okay.
Yeah, I think that would be fine to add as section 5 sub 5, and we can, with the committee's consent, it'll come back for council approval in any event. So we'll tweak the wording on that.
Okay. So I move to amend the motion to change 5.4, changing the word facts to information and facts, and to add section 5, clause 5, that references council being able to direct staff to seek a legal opinion at cost to the city.
Just before we go on to discussion, would it perhaps be advisable to simply allow staff to make the amendments that staff would like to make instead of being that specific? Just a question as far as I'm concerned.
So in relation to my motion, right now the committee is recommending that we adopt this policy. And so if we want any changes, we should tell staff what those changes should be.
Okay. Discussion?
Uh,
Councillor Dowd, sorry, you're first on the list here.
Yeah, I was hoping we would have a little more time to investigate what we're talking about before we have motions. And I'll say off the stop, but I think it's premature to start trying to move a word or two around. I think we should figure out what we want to do with the general policy. I wanted to point out that this is not the only thing that speaks about conflict of interest. We have a bylaw, we have a code of conduct bylaw that speaks specifically about conflict of interest and how to deal with it. For example, in part 2, it's part 2, investigation, compliance, and enforcement. You is to submit a complaint to the corporate officer, not the CAO, but the corporate officer. So that's two concepts of the same thing. One talking about legal opinions about conflict of interest, one talking about complaints, a totally different way of starting a complaint procedure. Number 2, it says the first thing on the written complaint would be name of the complainant. Also, all of those things go to the corporate officer. And there's, it's a really well thought out, because it took years actually for council to come up with this code of conduct, and the investigation process takes into account pretty much all of the things that come up. Putting things into the hands of an external independent investigator, making sure that when you do an investigation, it requires some important things, like if I can pronounce that right, procedural fairness and natural justice being included as part of the recommendation for the investigation, which is not in the policy at all. It also talks about anything that might or could commence a disqualification proceeding under Section 111 of the Community Charter in relation to the matter that is subject to the complaint must immediately be suspended, that investigation, until the proceeding under that Section 111 has expired. So, I think we're setting up another parallel investigation process with different parameters. And I think that's dangerous. It's hard to get that natural justice, which it should have, and the procedural fairness, if there could be more than one. I would rather than try to patch together a bunch of amendments to try to change this, to ask staff to take another look at it in conjunction with our code of conduct policies, and try to get some things that are consistent one to the other. When I saw the heading, I thought, well, staff is just simply wanting to clarify that the city is not going to pay the legal expenses of a counselor who wants legal advice on whether they should declare a conflict of interest or not. But this is more than that. It's a whole separate investigation procedure that parallels but is different than another investigation procedure we already have.
So, Councillor Dowd, I take it you are speaking against the amendment. I also heard arguments against the motion being amended, and I understand probably implicitly that you probably would have another motion. Is there any other discussion on the amendment?
Please don't assume implicitly that I'm going to do things. I'm not in favor of the amendment, and I don't think we should go ahead with this.
Thank you. Councillor Elliott.
Just one small point on the motion. It's not the motion you're amending, it's the actual policy. Yeah. So the amendment should read that council adopt conflict of interest and legal expenses policy 273 as amended. And then those points around the amendment are a separate action that we've been assured will happen because it's going to come back to us anyways. The points that George raised, I'm not as concerned about because this is simply a decision on whether to spend the city's money on a legal opinion or not. It is not a determination of whether somebody's in conflict or has done wrongdoing. That's not what's being investigated here. And they're not trying to resolve complaints. They're trying to decide whether it's in the city's best interest to spend money on a legal opinion or not. So they're different kinds of things. The only thing they would investigate would be maybe some precedents around whether the city ran afoul of not getting legal opinions in other situations that might have been similar in precedent setting across the whatever, and trying to make sure they got the facts straight so that they can make that determination. It isn't an investigation of a complaint in the same sense that the code of conduct talks about. So they're different things. But so I'm fine with the amendment as long as we're just saying that we're not trying to put those amendments for the document into the motion.
Yeah, thank you.
Okay, two questions for the corporate officer. Do you agree with Councillor Elliott's statement as to the intention of this policy and with regards specific, number two, with regards specifically to instructions as for the amendment? Now I'm starting to get a little confused. Was that clear as well? I get the intent, but was the wording correct or good?
Yeah, I would agree with what Councillor Elliott has suggested in terms of the motion that is before you, which is that council adopt conflict of interest and legal expenses policy 273 as amended, takes into account the direction that was provided in the course of discussion with respect to the substantive amendments within the policy. I also agree with Councillor Elliott's assessment that this is about when and how to seek legal advice on behalf of the city versus when it is the responsibility of a council member to do so, as opposed to conducting a parallel conflict code of conduct investigation. So,
thank you. Any other questions or arguments specifically to the amendment? Councillor Dowd.
Could we see the motion we're voting on?
Yeah. Excellent.
Excellent.
That good and clear? Any other discussion with respect to the amendment? Seeing none, all in favor? Opposed? Seeing none in opposition, that is unanimous. The amendment passes. Now to the amended motion that is on the screen. Any further discussion on the amended motion as it is presented on the screen?
Being amended again.
Sorry?
It's being amended again.
Oh, yes, like the highlights are being taken out. Okay, any further discussion? Wait a sec. That's the motion. Any further discussion? Seeing none, all in favor? Opposed? One opposed, Councillor Dowd. Motion passes. Thank you very much, Mr. Corporate Officer.